Great. Hello and good morning, everyone. My name is Roy Magara. I'm an employment law solicitor at Magara Law, which is my own employment firm. And I've got the real pleasure of co-hosting today with Bluestream Recruitment. Before I go on, Belinda and or Mike, I'll pass on to you to say a bit about what Bluestream Recruitment is all about.
Good morning, everybody. Thank you for joining us. Bluestream Recruitment has been on the Harvard campus now for must be 12 years. We work across engineering, particularly in the space and satellite communication sector. We also do the office support, which includes HR and finance, and sales and marketing. And that's us really in a nutshell. If you need any help, you know where we are. Thank you for joining us.
Super. Thank you kindly, Belinda. And everyone, you're welcome to use a chat or just unmute yourself or put up your hand or whatever the case may be. This whole particular one is going to be about employment law updates from this point onwards. We're also going to take a snapshot on a number of really important cases that have taken place in 2021, and we can see how they have affected everything so far and where we're going. You'd be glad to know there's not much COVID-related legislation that I'm going to be going on about, most of which has been uprooted anyway. But I will point out a number of key cases which may or may not have something to do with COVID and what's been going on. So thank you again. This is being recorded, so for anyone who hasn't been able to make it, it is March 2022 and everything is relevant from this point on. Hope you can all see the screen, and let's dive in terms of what we're going to be looking at. Before we do, actually, it'll be helpful to know, for those of you guys who are here, feel free to put into the chat box sort of who you are and where you're coming from in terms of your occupation, and perhaps what you're looking to get out of this webinar, which would be helpful for me to have some indication too. And in the meantime, let's dive in. So I want to start off by looking at some recent cases, mainly of which have happened since 2021. And the first one just concerns the status of workers, and that's the case of Uber and Aslam. Most of you guys know Uber. If you don't, they're in the same sort of category of something called the gig economy, which is where people can download the Uber app and then turn themselves into taxi drivers effectively. That's essentially what that's all about. In this particular case, there's been much dispute over the years about whether they are employees or whether they are self-employed or some other kind of variation of workers. The reason why that's so important, particularly for a company like Uber and other companies like Deliveroo have been under the hammer in these sorts of cases, is because as an employer, if you have employees, then there are plenty more rights that employees have as compared to workers. And in this particular case, where it was found that Uber drivers are definitely workers, definitely have the status of workers, things like holiday pay, sick pay, for one, over a huge number of years had a massive detrimental financial effect on Uber, and of course, great profitability for the workers there. Every case is, of course, turning on its own facts, and Uber Deliveroo followed the same line of argument here. Next was Coastal UK and Dunkley, and this one will be of particular interest for employers who recognize a trade union. So in this particular case, the Supreme Court held that making a direct pay offer to employees covered by a collective agreement is unlawful. So such direct offers can only be made once the collective bargaining process has genuinely been exhausted. So employers who recognize a trade union need to ensure that you follow any collective bargaining framework agreed with union first before making any direct offers to staff. And hopefully, as everyone can see so far, I'm not focusing on a particular niche or area. I'm going to be covering as much employment law as possible, and which will hopefully give both employers and employees a good idea in terms of where they're at. And let's then jump over to the case of Forestarter and CGD Limited. So CGD stands for the Centre of Global Development, for anyone who's wondering. We've got one who's definitely thirsty for knowledge in the group, and we have a coach too. who's into training. So hopefully all of these cases are helpful for you. Now, in this particular case, the Employment Appeal Tribunal held that gender critical beliefs are capable of being protected under the Equality Act 2010 as a philosophical belief. And while this is the case, so this case will go back to the Employment Tribunal, where they've got to determine whether the CGD decision not to renew Ms. Forstater's contract amounts to unlawful discrimination. Where as far as she's concerned, this includes where a belief that sex is immutable and that transgender women are men, which is her belief. And her employment contract wasn't renewed, and that's why she brought this particular claim. And that's what the Employment Tribunal held. A couple more meaty, I say meaty cases, they're all meaty, but a couple more cases where I'll provide some facts just so we can have a better idea in terms of what's gone on. The first case I wanted to bring up was that of Slade and Biggs and others who were the respondent. Now, in this particular case, so Biggs and Stewart were employed by the respondent, and in 2017, they both became pregnant. The respondent found this, quote, highly inconvenient and decided to engineer their departure, in short, from their employer by failing to pay things like statutory maternity pay, ignoring grievances and conducting a spurious TB transfer. Now, Biggs resigned and claimed constructive dismissal. However, Stewart was dismissed for gross misconduct whilst recovering from a premature birth from her child. So the tribunal described the disciplinary process as having been, quote, entirely spurious and vindictive, and that's frankly not surprising, and commented that her suspension, rather, and dismissal was one of egregious acts of discrimination possible. And the Employment Tribunal also increased the compensation by 25% because there was no ACAS code of practice on disciplinary or grievance procedures followed. Now, interestingly enough, the respondent appealed, and they appealed on two grounds. One, that it wasn't a discrimination, and secondly, that the 25% increase was unlawful. And the Employment Appeal Tribunal, unsurprisingly, dismissed both appeals and upheld that the tribunal had been entitled to apply the 25% uplift to the awards for aggravated damages and injured feelings, given in particular this particular case, the serious pregnancy discrimination. I don't know anyone who's here listening today may know of anyone, or maybe have been yourselves in situations where you've been subject to pregnancy discrimination, or you know someone who has been. It'll be interesting to know of people's experiences. Feel free to put them in the chat, or if you want to say something, let me know and then I'll let you speak. Or in fact, any other things that we're talking about today, if anyone's got an experience to share or a question to ask, please feel free to put that in the chat. Moving on, in the meantime, while people tick away at the keyboards or think of questions to ask, there's a case of Shell and Tarmac Cement and Lime Limited. Now, this particular case concerns if one is injured at work. And I have a number of cases where people are injured at work and they bring claims. But one of the key elements of bringing such a claim with an employer is causation. And then again, it's not just causation. There are a couple of other elements to that too. Hopefully this case will help people understand the sorts of things that tribunals think about and have to consider. First of all, in this particular case, the claimant worked on a site operated by the respondent. He was employed, and while he was providing services to the respondent, one of the respondent's employees deliberately hit pellet targets with a hammer very close to the claimant's ear, apparently as a joke. And subsequently, an explosion happened when one of the pellets was hit, and that caused the claimant to suffer noise-induced hearing loss and tinnitus. Now, the claimant then brought claims for personal injury against the respondent, i.e. the company, arguing that it was vicariously liable. In other words, it took on the liability for its employees for their actions, and therefore that the company owed him a duty of care. in failing to provide a safe working environment. Unfortunately for the claimant, the claim failed, and the claimant then appealed to the Employment Appeal Tribunal. That appeal was dismissed, and so the claimant then appealed to the Court of Appeal. Now, interestingly enough, that appeal was also dismissed, and the Court of Appeal reasoned that the correct approach was to ask whether an employee was acting in the course of their employment when they carried out the act complained of. The act in this case being the hitting of the pellets, which subsequently caused the explosion, which subsequently caused the noise-induced hearing loss and tinnitus in the claimant's ear. The Court of Appeal held that the respondent was not directly or vicariously liable for personal injury because it was a practical joke gone wrong. The employee was not acting in the course of his duties. He had steered well away from the course of what the employer would have expected the employee to do in that scenario. And because of that, the claimant wasn't able to pursue that claim for personal injury, which doesn't sound fair in many respects, but that, for what it's worth, it is how courts, it will go to the Supreme Court for what it's worth, and there might be a different decision, but that, at least at the moment, is how courts are viewing this particular issue of personal injury at work.
Right. Were the pellets anything to do with the working equipment, or was that brought on to site? The actual.
Yeah. As far as I'm aware, they were part of the equipment, etc. The distinction was that employees were not told to hit pellets as part of their work.
Okay. But they were kind of in the
Yeah, quite right. Doesn't seem very fair.
You wonder if it was the first time that had ever happened.
Yeah, indeed. I mean, it does remind me of a case which didn't go very far, unsurprisingly, but a number of years ago, of an employee who worked at an establishment, shall we say, I've got to keep this as plain as possible, at an establishment in security. And he and his fellow colleagues like to play practical jokes on one another. Now, one of those practical jokes was to get some pins, which you'd naturally put in a cardboard board or something like that, and sort of somehow put them under the seating of the chair of one of their colleagues. Colleague comes in quite shattered from walking around the establishment and sits on the chair. And unsurprisingly, gets a very nasty surprise following having sat on a heck of a load of pins which have been hidden in the seat cushion. Now, in that particular scenario, the employee, yes, he was injured, he was bleeding, he actually was concerned about contracting other diseases like AIDS or tetanus and what have you. And he actually just brought a grievance, and all of those particular colleagues were dismissed. He hadn't escalated that to a tribunal or otherwise, but it's interesting to think about where that particular case could go if that employee only brought claims against the respondent as opposed to the individuals as well, which is perhaps what this particular individual should have done in this case. So hopefully that's more insight, but thank you, David, for that actually very helpful question.
Very interesting.
Next one, briefly, we're going to look at a COVID-19 related unfair dismissal claim. It's no longer going to be the case in a couple of weeks, and I'll talk about that in a bit more detail, but the mandatory vaccination requirements are going to be lifted as far as the NHS and care homes are concerned. Those are governed by the CQC. But this particular case of Allet and Scarsdale's Grange Nursing Home Limited concerned the respondent who had made it mandatory. And this was actually in 2021, prior to the government itself making it lawful for staff to be vaccinated in its workplace following an outbreak of COVID in its nursing home. Now, that's because the case numbers were high. As I say, the vaccination program had been rolled out, but there was a serious outbreak, and the respondent was concerned that its clientele were particularly vulnerable. Now, in this particular case, the claimant refused to have the vaccine, and her initial explanation was that she mistrusted the vaccine, its effectiveness, its safety, She'd actually highlighted a number of conspiracy theories that she'd been looking at and a number of websites she had been on, and had cited a number of reasons why. The respondent then brought forward disciplinary proceedings against her, and it was at a later stage that she then said that she didn't want to have the vaccine because of her religious beliefs. And her religious belief that she relied upon was her Rastafarian beliefs. And in the context of that, it was that she believed in only using herbal natural remedies, and the vaccine wasn't a herbal or natural remedy. The respondent didn't accept that explanation and said it was one she'd given much later on, and perhaps was one she just made up off the cuff. And that's why they dismissed her eventually, because she still refused to have the vaccine. She brought a claim for unfair dismissal and discrimination. However, the employment tribunal dismissed her claims in their entirety. And the reason they did that was because the employment tribunal held that that the respondent rather had a legitimate aim in instructing employees to get vaccinated, and for dismissing her when she refused to comply, when she was insubordinate. And equally, the respondent believed that in actual fact, the main or the real reason for her not taking it was for her fear and skepticism around the vaccine, as opposed to a religious belief itself. And that's a really interesting point, because I was involved in a case only a couple of weeks ago of, and I can't go into the facts too much, but of an individual who had raised complaints, who was under disciplinary proceedings from work, and had raised at a much later point a discriminatory issue to do with that person's health as a reason why a certain misconduct had happened. The employment tribunal in that particular case had found that while an employee should not be pinned down or rebuked or otherwise just because a reason has been brought up at a later stage, albeit even appeal, they still have to look at what they believe the real reason was, irrespective of the stage that it was brought up. And this case is proof of that. So moving on from that particular case, I'm going to change over the slide. A couple more cases just to bring to people's attention before we dive into another section. Sleep-in shifts and national minimum wage. We have a couple of people in the medical sector here, and a few who couldn't make it but wanted some clarification on this particular point. For the case of Royal Mencap Society and Tomlinson Blake, that case has actually been decided since March 2021, but there's still some misunderstanding in terms of what the law actually is. In short, the court held that individuals carrying out sleep-in tasks are not entitled to national minimum wage for time spent asleep. So I'll repeat that. Individuals carrying out sleep-in shifts are not entitled to national minimum wage for time spent asleep or near the workplace, for what it's worth. They're only entitled to national minimum wage when they are awake for the purposes of working. And that's really specific. And again, that's gone to the Supreme Court. So that's it. There's no other escalation that the parties can get to, but hopefully that's a really helpful clarification for whoever wasn't aware where the buck lies when it comes to national minimum wage and sleep-in shifts. And that, for what it's worth, will be a particular key decision for those in the charity sector, and of course for those in the care sector as well, particularly those who may have faced a significant liability for historical back pay, for example, or otherwise. Next, the case of Ale UK Limited and Gellen. So in this particular case, it was an employment appeal tribunal case. And this emphasizes, simply put, the importance of anti-harassment and diversity and inclusion training being up to date and fit for purposes. There is a real dearth of competent training that goes on in companies these days. And perhaps the coach of the group may or may not agree in terms of the experience there. But for what it's worth, in this particular case, the employer's, quote, stale diversity training wasn't enough to defend the claim of harassment which was brought by an employee who had been subject to racist comments by a colleague in the workplace. So again, employees are normally responsible for discriminatory or harassment acts committed by their employees. However, there is one statutory defense under the Equality Act. And that is where an employer can show that it took all reasonable steps to prevent the employee from doing that discriminatory act. And that, in very many respects, is equal opportunities training is the main buzzword that's around. But the Employment Appeal Tribunal highlighted that just simply having a policy and putting on equal opportunities training once a year or whatever the case may be is actually not enough. The policies ought to be regularly reviewed, and refresher training ought to be provided as and when needed. So much more than just that kind of once a year smack on the internet somewhere gathering dust approach is necessary. I don't know whether anyone on this particular next point concerning menopause knows much about this. I did a webinar on this a couple of months ago now, and it's on the YouTube website too, on the firm website if anyone wants to have a look at that. But menopause is becoming a much more topical subject, and rightly so. In fact, it's a shame we're only talking about it now, when we should have been talking about it years ago. The reason why I'm highlighting this particular case, so this is Rooney and Leicester City Council, is because there was a question asked, and simply put, it is, can menopause symptoms amount to a disability? And the direct answer is yes. So in this particular case, thank you for the comment there in the chat box. In this particular case, while menopause itself isn't specifically mentioned in the Equality Act 2010, this case particularly shows that there's no reason why, in principle, why menopausal symptoms cannot have any relevant disabilitating effect on an individual to afford any protection under the discrimination from discrimination under the relevant act. So, to give some very brief insight, menopausal symptoms can include that brain fog, fatigue, anxieties. We know that the hormonal imbalance can cause a number of both mental and physical adverse effects on women who go through the menopause. And that's why it's important for employers to be clued up on that, because I'm not going through this particular subject for this particular webinar, but there are a growing number of cases where menopause is at the center. So again, not every single menopause case will be able to catch that disability banner. It very much depends on the symptoms. But again, this is not a topic of discrimination, so I'm going to move on. But check out the menopause webinar if you haven't already. It was a really great discussion, and hopefully you can gain much from that too. Next particular case to discuss for anyone who is going to be offended by my pronunciation of this particular council, but Gwynedd Council and Barrett and others. This was a Court of Appeal case, and in short, it confirmed that the failure to offer an appeal in a redundancy situation does not in and of itself automatically render a redundancy decision unfair. So I'll repeat that because it's really important, and the reason why it's really important is because it is commonly pleaded that because a particular stage may have been missed out, and in this case it was the appeal, that it rendered a particular decision unfair. So the Court of Appeal in this particular case confirmed that a failure to offer an appeal in a redundancy situation, now again, I'm not talking about misconduct or capability or otherwise, I'm talking about redundancy here, does not on its own automatically render a redundancy dismissal unfair. The court, of course, held it would be wrong not to go through the appeal process, etc. But just because it lacked that and it was defective doesn't mean that the process itself could not have otherwise been a fair process. So instead, what a tribunal will look at is a much more broader perspective on the subject, and will look at all the factors in any process before determining whether the redundancy process itself was fair or unfair. hopefully that helps, and hopefully I've made the real distinction in terms of redundancy, as opposed to everyone getting ready to bring claims against their employer because an appeal has been missed out for any of the other reasons.
So would they have had to have then taken action, or would there have been any consequence of them missing the appeal?
Well, in this particular case, it was held that it wasn't an unfair dismissal. So the respondent wouldn't have had to do anything in that sense, but they definitely would have had to check themselves and make sure that next time they don't fall foul, because the reality is they're in the Court of Appeal and it might go to the Supreme Court, who knows. The amount of money they spent defending this and defending all the appeals, it is enough out of pocket to ensure that they make sure the next time this happens, they won't do it again.
I get you.
Super. That's a great question, and that's certainly one of the morals of that particular story here. Okay, that is not gender pay gap, that's gender pay gap. So apologies there for the typo, but at least it shows we're all human. Now, concerning the gender pay gap, along with my mispronunciation perhaps of the council just beforehand, in this particular case, which is Bayfield and Jenner and Wunderman Thompson UK Limited, this generated loads of headlines in 2010. And this is because of a, shall we say, cautionary tale for employers looking for that kind of quick knee-jerk fix to address gender pay gap issues. I'll explain a bit about the facts, and then I'll explain why this is really important. So before publishing their, quote, embarrassing gender pay gap report, the respondent in this particular case, which was an advertising agency, gave a presentation at a conference pledging to, quote, obliterate its reputation for being full of, quote, straight white men. So unsurprisingly, two claimants who were white British heterosexual men in their 50s raised concern with the messaging, and rightly so. However, oddly enough, they were dismissed shortly afterwards as part of the respondent said, wider redundancy exercise. Somewhat unsurprisingly, the tribunal upheld their claims for sex discrimination because it found that the so-called redundancy process was absolutely bogus, and rightly so. So their claims for sex discrimination, victimization, and unfair dismissal were all upheld. And that decision, and why I'm raising it today, simply highlights for us that there's no quick fix to addressing systematic gender pay gap issues. Promoting one group of employees over the other at the other's expense is most likely going to be an ineffective way of dealing with it, and potentially, as this case shows, unlawful. If anyone doesn't have any other comments or thoughts to share, I will jump onto the next slide. If you do, of course, have comments, feel free to put them in the chat box. Otherwise, I'll press on. So next, let's look at what's happening with flexible working. So a consultation, at least was closed in December 2021 on this particular topic. And that consultation simply sought proposals to extend the existing right to request flexible working. You may be aware at the moment there's a sort of nationwide proposed trial of the 4-day week. Those of us who are self-employed or run our own businesses may not have a 4-day week, you might have an 8-day week, but at least the prospect of a 4-day week is a dream that some of us may at least continue to think about at some point. But those of us who can get there, all power to you. So these proposed changes, at the very least, are intended to form part of what, at least for the past couple of years, the can keeps being kicked down the road, but of what's going to be eventually called the employment bill, whatever that's going to look like. And I'll talk about a few more bits of that much later on in today's webinar. So a couple of, well, there were 5 proposals actually that were set out in this consultation, and those included making the right to request flexible working from day one a right, as opposed to 26 weeks in to your employment, which it currently is. The next is whether the 8 business reasons for refusing a request all remain valid. I'm not going to go into those, but there are 8 reasons a business can give. And there's a consultation as to whether they're going to be more, less, or flipped or changed or amended in some way, shape, or form. The next proposal that's going to be considered is requiring the employer to suggest alternatives. At the moment, it's very much, sorry, we can't allow this request because of a business need, for example. This time, an employer may be obliged to suggest alternatives themselves. Another proposal is requesting a temporary arrangement. And last is the whole administrative process underpinning the right to request flexible working, which again, I'm not going to go into now, but because it's not a topic on flexible working either, but those are some of the highlights that are going to be considered. I've been asked if an employer can ask an employee to work additional hours over 4 days. If you wouldn't mind just contextualizing that question a bit more, that'll be helpful, please.
Yes. Sorry, it was a question that got asked by a client. They were considering 4 days a week, but they couldn't imagine their employees doing the work over 4 days when they struggled to do it over 5. And therefore, could they condense the 5-day week into a 4-day week? Is that allowable under this new 4-day working week?
Yeah, great. Great question. So to begin with, it's not law, it's not i.e. all employees must now be on 4 days. Yeah. So employers don't need to feel the kind of pressure to figure out some kind of way to kind of squash all the hours in. Yeah. Employers have also got to remember that they can't unilaterally change an employer's contract. In other words, they can't say, you're going to do your 37.5 hours in 4 days now, like, take it or leave it. That'll be a breach of contract, and they'll open themselves up to claims. It's very much up for discussion. If an employee says, you know what, let's try and make it work, what I would always suggest to employers in this particular scenario is have a trial period of time. If an employer is not sure, but an employee says, no, I think I can do that, have a trial period of a month or 6 weeks or whatever the case might be comfortable for both parties. But an employer can't oblige an employee to work additional hours in this context.
Okay, and also with regards to, them changing over maybe and agreeing to that they will do this, and they have a trial period and it works, and then the employee decides, actually, I've changed my mind, I want to go back to, is the employer then obliged to go back to doing the 5 days a week?
Yeah, great question. I suppose employers have got to remember that it works both ways. Yeah. There's no sort of imbalance to this particular process. So just because, for example, an employer wants that to happen, doesn't mean that it should happen. An employer might suggest, well, now there's a business need for one to do the 4 days. But again, that's going to be a tall order, because it's ultimately going to be dismissing an employee who says, well, I don't want to do 4 days actually anymore. I get that it worked, but actually it doesn't work for me because of 1, 2, 3, 4, 5. So an employer has still got to be careful. Both parties have got to agree.
Okay, that's great advice. Thank you.
And for what it's worth, Belinda, the same approach goes for the employee. Just because the employee thinks it works and wants to keep that doesn't mean it can oblige an employer to keep that, especially where it's agreed that there'll be this trial period.
Okay. Thank you.
You're very welcome. Great. Okay, so that's all that's happening with flexible working in a nutshell. Let's talk about some of the statutory payments. This is all fairly factual in nature, and hopefully you can see on the screen there all the facts and figures for you. I'm not going to go through everything in detail in that sense, but hopefully you can see on the screen there's going to be what employers will think of as a significant increase in fees. Employees always sort of celebrate with arms up, and that's, again, all power to employees. Employers, national minimum wage, etc. These are the sorts of things that you've got to budget for. And that's why, at least generally speaking, there are concerns about rising living costs, rising costs of food and services, the list goes on. But the reality is, as the national minimum of living wage continues to rise, so do other costs rise as well for a business too. So we can see there, and I'll just highlight a couple of ones. For the age group 23 and over, currently it's £8.91 per hour. It's going to increase from April this year, 2022, to £9.50. For the 21 and 22-year-olds, it's £8.36 at the moment. That's going to increase to £9.81. And as you can see there, there's an increase in those other areas there for 18 to 20s, under 18s, and apprentices. Interestingly enough, and I don't know whether many people know this, but a new social care levy is going to be introduced in the UK-wide from April 2022, well, specifically the 6th of April 2022. And this is to help fund the health and social care sector. So this is going to be collected by via a 1.25% increase in national insurance rates for employers, employees, and the self-employed. So just to be clear, it's not going to be payable by those earning under the NIC's threshold, which currently for the current tax year is at £9,568. Okay. So this particular levy is going to be collected under a separate health and social care levy at a rate of 1.25%. Also, by the way, people above the state pension age won't be affected by this temporary increase to national insurance contributions for the 2022 to 2023 tax year, but will be liable to pay the levy from April 2023. Hopefully that's clear. Next, quick snapshot in terms of what's colloquially called, or in the legal world, family-friendly leave. And I've highlighted the relevant statutory family-friendly leave payments there, from maternity through to adoption, paternity, shared parental pay, and parental bereavement pay. In short, these rates are going to increase to £156.66, up from £151.97. And those normally take effect from the first Sunday in April, which is the 3rd of April. So again, employers, you need to note that. Again, another quick snapshot in terms of sick pay. So this is statutory sick pay. That normally rises every April, and this April is no different. That's going to rise up by 3.11%. So the new rate is going to be £99.35. And that's £3 up from £96.35. Righto, let's get out our crystal balls and have some idea, some which we're certain on in terms of dates and times, and others which we're not so sure on. But this particular section is just to give everyone a kind of snapshot idea in terms of where, at least employment law speaking, we're going moving forward. So first, and so from the 15th of March 2022, I talked about this in some very brief detail earlier. From the 15th of March 2022, laws requiring mandatory vaccination for those in care homes and those working in the health and social care sector are all going to be revoked. It'll be interesting to see what the reaction is from those who have been in those care sectors, who for one reason or another didn't want to take the vaccine, had to leave, and now they can come back. And particularly during that period of time, sort of autumn through into the winter, and even as early as January and February this year, I've had loads of inquiries from people 15, 16 years in the health and social care sector, in the NHS, which wasn't as affected as the health and social care sector, at least those regulated by the QC, who are then saying, right, what claims do I have? Have I got an unfair dismissal claim? Is there anything that I can do? These are questions which no doubt are going to be raised following this news.
Just a quick one on that one. If somebody's dismissed somebody because of this not having the vaccination, and they reapply for their job, as an employer, are you obliged to take them back on?
Sure, great question. Well, an employer cannot use the reason that, well, you haven't got a vaccine and it's mandatory for you to have the vaccine as a reason not to employ anyone anymore. However, it is still open to employers whether they want to enforce or not enforce the mandatory nature for vaccinations for their staff. Now, what employers cannot do, easily at least, or without much risk, is change the contracts of their current employees to say, right, current employees, you must now have the vaccine. And employers got to show a reasonable reason, go through risk assessments and what have you, as to why it is necessary for the employees to have the vaccine in this context. And of course, run the risk of claims. But if you have an incoming employee, and that includes those in this scenario you just raised, those who work there, left, but now want to come back in, an employer still got to go through that same exercise of risk assessing and whether it's reasonable for their new staff to come in to have it.
If that employer should use some other excuse to not take them back, are they opening themselves up to a claim?
Possibly, although it sort of depends what kind of claim that employee could bring. It's unlikely, unless of course it's part of the facts, that they'll have a discrimination claim. They can't bring an unfair dismissal claim or any other sort of claim. So apart from being very disappointed in the said employer, fact depending, it's going to be quite difficult to think about what claim they can bring.
Okay, thanks for that.
You're welcome. So the main risk is for those who are currently still employed by said employers who might want to change their contracts in that regard. Okay, great. And as you can see there, most of these, as you can see, are to do with COVID in some way, shape or form. We know that the restrictions for all intents and purposes have lifted, at least from a governmental point of view. And we'll see here that the statutory sick pay rebate scheme for COVID-related sickness closes on the 17th of March. So in a couple of weeks. By the 24th of March, as you can see there, our COVID-19 provisions within the SSP and employment and support allowance regulations will be removed. And that includes, by the way, statutory sick pay payments for those isolating, unless they're too unwell to work, and the payment from SSP from day one. And as you can see, that all claims under the SSP rebate scheme for COVID-related sickness must be submitted, and all amendments to claims made by the 24th of March as well. Next, we'll journey through
There's a question there, Roy.
Oh, apologies.
Question came into the box.
Yes, thank you. Can an employer put an employee on sick leave? If you're asking that, is that a sort of general question, or is that something, or are you able to contextualize that a bit more? If it's general, I would suggest it depends on the facts. Or some such a lawyerly answer to give, but the reason I say that is because there was a case. The name escapes me at the moment. Okay, general, great. So the name of the particular case escapes me at the moment, but there was a case recently where an employee was put on sick leave by the employer and was, for all intents and purposes, from the employee's point of view, forced to have an appointment with occupational health. He, very long story short, brought a claim for discrimination and harassment because the employer did this. And interestingly enough, the employment tribunal upheld his claims for discrimination and harassment because the employer in that scenario had been found to be indeed harassing him and forcing him to do something he didn't want to do, and putting him on sick leave, which of course had an effect on things, well, mainly his pay. So I would suggest, based on cases like that, the answer is no. But again, an employer may have the point of view that it's in the interest for the employee to go on sick leave because the employer has a duty of care toward its staff. And if an employee is of the opinion that it is reasonable to put an employee on sick leave, then it may do that. But again, it's all very fact specific. But hopefully that answers the question from the general point of view. Thank you, David, for highlighting that.
Therefore, if somebody comes into the office unwell, can an employer insist that they go home and work from home as to not spread any germs? Yeah,
quite right. Great question. And I think COVID has all taught us that the answer to that is most likely going to be yes. An employee has got to follow reasonable instructions by the employer. So it would be reasonable. And even if it's just the common cold or common cough or whatever, we're much more now sensitive to the spreading of germs just because it's not COVID doesn't mean, especially where one can work from home, an employee shouldn't work from home. So yes is the answer to your question directly.
Thank you.
You're welcome. And thank you for the person who asked that question in the chat box too. Thank you, David, for highlighting that to me. I hadn't seen that. Thank you very much. Okay, well, hopefully everyone can see on the screen the various points of law. I'm not going to read everything out verbatim, but I'll just highlight the main points. I already noted earlier the family-friendly legal rights, as it were, those payment rates that are going to increase. And you can see those listed there in terms of the maternity pay, the adoption pay, shared parental leave, etc. That's all going to be kicking off from the 3rd of April 2022. For those in the more immigration-centric sphere of employment law, from the 6th of April, we can see there that the ability to manually check the status of those with a biometric residence card or permit or frontier permit, that's all going to be revoked. And we can see that the law there is going to change as it is on the screen. And I mentioned earlier about that health and social care levy as well. We can see that increase taking place, that 1.25% from the 6th of April too. In terms of what's ahead and what we don't have a date or confirmation yet, a number of things are flagged to everyone's attention, which will hopefully, well, it will be of use in some way, shape, or form to one person, if not the other. So first thing I'll highlight is to do with a new law prohibiting confidentiality clauses in contracts or settlement agreements, which used to be called compromise agreements way back when, from preventing disclosures to the police, regulated health and care, or legal professionals to be introduced. When is that going to be introduced? Absolutely no idea, unfortunately. But that's going to be something that's very welcome, particularly by those who were part of things like the sort of hashtag #MeToo era, those who suffer harassment or discrimination at work, where there's some kind of criminal element to it as well. To give a practical illustration of why this is important, a lot of cases, well, if a case doesn't go through to a final hearing in a tribunal, unless there's been an order for it to be held privately, it's going to be on public record for the world to see, particularly where, well, in situations where a written decision has been requested, the written judgment has been requested. If it's settled beforehand, it's typically settled in something called a COT3, C-O-T3, or in what's now called a settlement agreement. And 99.9% of times, there's a confidentiality clause in there. It says, in short, the claim is not only withdrawn from the tribunal proceedings, but that the claimant cannot talk about the circumstances leading up to that COT3 or settlement agreement, or the settlement agreement itself. So it's as if nothing has ever happened and the world goes on and one can't say a bad thing about the other, and that's about it. But this particular law is going to flip that on its head, because it means that there are going to be some people whom these people in these particular circumstances are able to share that information with. So to put it into practice, someone's been sexually harassed at work and they bring a claim. That particular individual might also want to disclose it to the police or some other kind of authority to escalate that in a different forum. Currently, it's going to be quite difficult for them to do that, but this law opens the scope for them to do that, which is really important in my view, at least. Next is to do with laws on criminal record disclosures. That's going to be amended, and in short, that will reduce the disclosure period for sentences lasting 4 years or less. There is also going to be a new law introducing rights for all workers to request a more predictable and stable contract after 26 weeks service to be introduced. That will be much more pertinent for those who are on, for example, 0-hour contracts or on much more flexible working contracts, as opposed to those who've got set hours and set times, etc. And hopefully that assists that snapshot I've given just there. Next, there will also be, as far as the continuous employment point, which I'm on now, a new law to increase the break in continuous employment from 1 week to 4 weeks to be introduced. What on earth am I talking about? So continuous employment is something that's really important in employment law cases. And that's particularly because at the moment, when an employee hits 2 years continuous service, in other words, no break in their employment with an employer, they open up to other rights such as the right to bring a claim for unfair dismissal, to redundancy, etc. If an employee leaves a job, goes somewhere else and thinks, actually, I don't like this new job, I want my old job back, an employer is only under an obligation to show that there has been a continuous employment, even though there's been an end and a beginning, if that all happens within a week. Hopefully that makes sense. Now it's going to be extended to, well, eventually at some point, that'll be extended to 4 weeks. So an employee, for example, can say, okay, here's my notice, I'm leaving, has a 4-week period to trial said new job and possibly get their old job back and not have a break in their continuous employment. So they're able to retain those really important rights, like the right to bring an unfair dismissal claim or redundancy, etc. Hopefully that's clarified the reason I've highlighted that there. Then I've talked about the employment status test. Is there a question?
Yes, I was going to ask, where does furlough come into this? You know, where people were put on furlough?
Yes.
Is that part of continuous service? The time they were on furlough?
Yes, as a general rule, yes, because they're still employed.
Yeah, okay.
Furlough simply meant that there was no obligation for them to work, but still be able to pay it as much as possible up to whatever the threshold was at the time.
Okay, thank you.
You're welcome. Great. So let's see. Where was I? Employment status test. In short, and this really is going to be very short, there will at some point be some kind of legislation to help clarify employment status tests to be introduced. And the reason why that's going to be important, and judges are going to be very grateful for this, is because of cases like the Uber case I highlighted earlier. And I've mentioned a couple of other employers as well who have been under the spotlight, like Deliveroo, Hermes, and the list, believe it or not, does go on. There will also be a new law introducing tribunal sanctions where organizations commit repeated breaches to be introduced. What do I mean by that? So that, for example, in practice is where there's an employment tribunal claim. A tribunal will typically set out a timetable for disclosure, witness statements, or let's see, various other orders to be met, medical evidence, etc. But if parties breach that, if an employer breaches that, for example, doesn't disclose all they ought to, or doesn't agree joint medical experts, then a tribunal, which typically is much more, I'll say easygoing than civil courts, will be able to have sanctions that they can really hammer down on parties or on organizations who breach any particular order set by tribunals. Next, there's going to be an extension to shared parental leave. That's going to be able to be extended to grandparents, which is very interesting, coincidentally, as opposed to just parents themselves. And next, carers leave. I'll talk about this in very brief detail as well, and then I'll spend a little bit more time on a couple of these other points. But in short, there is going to be a right to carers leave, which will be introduced. For all of these points, they've been battered about for the last couple of years. I can only imagine that COVID has taken over the discussion as opposed to these particular points, but government still has every intention to ensure that these things which I've highlighted here will come into fruition in some way, shape or form. A quick one on pay and holidays. UP, for those who are employed, there's going to be an extra public holiday, which is going to be Friday the 3rd of June. Yep, has indeed. For those of us who work for yourselves, I can see you shaking your heads. That's no surprise, because you're probably working anyway. That's to mark the Queen's Platinum Jubilee, and the late bank holiday has been moved to Thursday, the 2nd of June, to make a 4-day weekend, or a 9-day week for those of us who work for ourselves. Next, harassment. And I'll touch on this in a little bit more detail than I have some of the other points. So the government, following much consultation and much case law, is promising to introduce a new proactive duty on employers to prevent sexual harassment in the workplace. And that, it seems to be, is going to be in the context of making employers responsible if employees are harassed by customers or other third parties. So you may remember I highlighted the statutory defense earlier for employers in discrimination scenarios, which is typically, as long as they can say, hey guys, we've done all we can to make sure our employees don't do anything, there's now going to be this extra obligation on employers to ensure that their employees aren't harassed by customers or other third parties. If anyone's wondering what are other third parties, that can be things like other agencies or consultants brought into the business, and things like that. So provision is likely to be made in that employment bill, which I'd highlighted earlier, that mythical beast which is yet to materialize. The response, for what it's worth, did confirm that it will introduce that duty on employers to prevent sexual harassment. So I know that there are all other kinds of harassment. This is specifically to do with sexual harassment in the workplace. And it will also, by the way, be looking to extend the limitation date that a claim for sexual harassment can be brought in this context under the Equality Act from 3 months, which it currently is, to 6 months. What on earth do I mean, for what it's worth, by that limitation date? So there is a period of time within which an employee can bring a claim against an employer. In other words, you can't just sit on an issue for 3 years and then go, oh yeah, I was really aggrieved by that thing that happened all that time ago. Every different particular legal issue has a particular amount of time. For sexual harassment under the Equality Act, it currently is 3 months. So again, there's going to be, there's proposed an extension for that to be 6 months. And I would suggest part of the reason for doing that is because, particularly in instances of sexual harassment, employees typically take much longer to speak out about that, as they may do about other areas of their working life. So next, as correctly spelled here this time, gender pay gap reporting. For those employers who are going to be caught by this, so for those businesses to whom this applies, just note the gender pay gap reporting for those in the public sector is due by the 30th of March. For those in the private sector, it's due by the 4th of April 2022. I'll repeat that. For those in the public sector, the gender pay gap reporting is due by the 30th of March 2022. And for those in the private sector, it's the 4th of April 2022. Last few bits here before we enter into the closing part of the workshop, of the webinar, neonatal care and redundancy. So the government has been pledging for a while, but it's most recently again pledged that it's going to introduce a 12 weeks paid neonatal leave for parents whose babies spend time in neonatal care units, which is really important and a long time coming, frankly. So although there's no set date again at the moment, this, as to when this is going to be introduced, it's expected that it will form part of, again, the employment bill, as and when that comes into fruition. Next, tips. So this is particularly going to be really pertinent for those in the hospitality sector. So the employment bill again may introduce regulations which will govern as to how tips are going to be distributed to staff. And for what it's worth, that is in response to a consultation that closed in 2016, and we're in 2022. So it's a long time coming here, really. But in short, those proposals are going to prohibit any deductions from tips other than taxes, and include a statutory code of practice as to how employers ought to distribute tips in a way that's fair and transparent, with written policies and tips and a record as to how tips ought to be dealt with, because different employers, different restaurants, etc., do different things that come to tips. And lastly, pregnant workers, but in the context of redundancy. So the UK has also committed to improve redundancy protection for pregnant employees and maternity leavers, returners rather, by giving them priority for alternative employment opportunities if they're made redundant. So currently there's no date set. Again, it's likely to be in the employment bill, time will tell. But these employment protections are likely to be similar for those that are afforded to those parents returning from adoption and shared parental leave. Those are the updates. There's so many, and actually there are plenty more, but I wanted to provide a snapshot of things that will be relevant in some way, shape or form for as many people as possible. Any questions, comments, complaints, or otherwise to share before we close?
Generally, I think it would be a good idea if you could just say to employers how they can protect themselves. Generally,
I didn't catch that, sorry, Belinda.
Your top tips for employers to protect themselves generally, what would your advice be?
Yeah, simply put, when it's in writing, it saves a lot of trouble. So most employers, not most, some employers still haven't realized that the law changed in April 2021 to say that an employee has got to have a contract from day zero or from day one, depending however you look at it. A lot of employers are still in the old mindset of they've got a couple of months to give their employees their contracts. And those employers who are in that particular category are opening up themselves to be liable for a number of weeks' pay if their employees bring claims for that. So that's the first thing I suggest. Make sure all of your employees have contracts. Secondly, even if you are an employee, an employer who is not obliged to have anything to do with gender pay gap reporting, there are still plenty of employers who are alive to risks of claims for equal pay claims, from whether it's men or women, whichever side of the field they sit on, who aren't being paid the same as their comparator. And on that particular point, I put this on my firm's website and on my LinkedIn. There was a case of, I think it's Sarah Mackin and Paribas, the bank, and she had brought claims against her employer for sex discrimination. And there was an equal pay issue there too. And in short, she was being paid considerably less than her male comparators. And very long story short, and again, there are lots of layers to this, and her salary had much to do with the award too. But she was awarded over £2 million in her particular claim. And so, of course, I don't want anyone to be listening to this and thinking, wonderful, my retirement set for life, because again, that's very fact specific. Not every claim, in fact, hardly any claim that's brought in this particular sphere is going to be seen with a claimant walking off with £2 million. But it just goes to show, again, if things aren't in writing, if employers don't ensure that people are on the same level playing field, that they are going to make themselves quite live to risk.
Thank you, Roy.
It's just an observation, Roy, but it seems like a lot of the employer now is needs to kind of rolling out lots of the change in attitudes and stuff. The employer is kind of the government's training provider for the population, and it's like, are they going to get support with that? You know, if you're taking your workforce out to do training on discrimination or some of these more difficult topics, it is a cost. So they say, well, I'm here to make money, and why should I be having to bring up people because they haven't been brought up through the system, if you like?
Yeah, really good point. And I suppose for you, someone in learning and development sphere I think you mentioned you typically help employers understand legal changes and hot topics that kind of govern the workspace. And you and maybe some of us or those watching this webinar will all be victim to be sat in in-house trainings given by managers who haven't got a clue of the topics they're talking about themselves.
Mm-hmm.
And the employees know it, the managers know it, and they're thinking, well, I've got to give it. Hopefully this makes sense to someone, and hopefully this just ticks a box. And that's not helpful for anyone. That's why there was a great resignation, as it were. That's why there's still, generally speaking, a high attrition rate in companies. There's just this revolving door of employees coming in and out. And you'll know perhaps more than most that what employers ought to be doing is investing in their staff, in their workplaces. What on earth what do I mean by investing? By investing, I mean they shouldn't be paying an external provider, learning and development, or otherwise, whatever the topic might be, an expert to come into their business and ensure that their staff are adequately trained. That's an investment, because their staff, an employer's staff are their greatest asset, and they should be looking to train their staff properly, as opposed to expecting their staff to train themselves on these important changes. So no, there is no governmental bid or pot, as it were, to assist employers in this regard. Should there? Perhaps yes, but then again, that money's got to come from somewhere, and I imagine the public won't be happy with another increase to any levy or tax. But employers should see it as an investment, as opposed to an expenditure when it comes to training their staff.
Yeah, good answer.
Great question.